So you, living man, woman, living soul, you're real, you've got substance. You don't actually ever step onto the artificial monopoly board of commerce that we're all playing. So imagine that you were sitting at a gaming table and on the table was a game of Monopoly. You are the living player, but you can't step on the board because that's not in the game, right? But you can have a player piece that goes round the board. You push that player piece around the board. Well, that player piece is the birth certificate construct, the decedent estate. It is registered to the state. It's theirs. Anything that is registered to the state is basically they have the legal title to it. They own it. It's theirs. Money of substance. Post 1933, money of account. No gold. The gold is confiscated. The system is now moving into a ledgering system, a money of account, an accounting system, as opposed to a money system backed by substance. We are now operating and have been since 1933 in an accounting system where it's all based on ledgers. Debt on one side of a ledger, credit on the other side of the ledger. It starts in 1913. You have the Federal Reserve Act. Then you have the House Joint Resolution 192, 1933. That's the transition from money of substance to money of account. And then you've got no gold whatsoever backing money in 1974. It takes all that time. It takes 60 odd years for it to transition from a money of substance system to a money of account system. Well, when banks take deposits, they're not taking pre-existing money in as a deposit. What they're taking in is a deposit of energy. So when you make a deposit into your bank account, that is human energy. When you sign up for a mortgage, loan or credit card, the bank isn't transferring anything from any savers. No, they're taking your deposit. You're depositing your energy and they are creating a matching liability equal to the face value of the mortgage, loan, credit card or bank payment. That's your deposit. That's the debt. It never existed before. That is ex nihilo creation. They hold it under these street name accounts, so you can't actually see very easily, unless what you're looking for, that these mortgages are all held in tranches. They hide them away, but the giveaway is that the investment banks pay taxes that back up withholding taxes for the use of the human energy, and they pay it on a specific tax module, which is called the 945 tax module. And that is the giveaway. If they were not debtors, if they owned the credit, the mortgage credit was theirs, they would not be paying taxes for the use of the energy. The fact that they pay taxes for the use of the human energy proves that the banks are no more than nominees. And that's how we do it. It's called Revenue Procedure 2002, 2026. It is an absolute right of the Foreign Grantors Trust, as the holder in due course, to invoke its right to step into the shoes of the taxpayer by filing what's called a Form 56 and to command the United States Treasury as the bankruptcy trustee for a creditor entity, which is the Foreign Grantors Trust, to redirect the taxes to the Foreign Grantors Trust and to redirect taxes also from other tax modules that the investment bank has paid onto the 945 tax module that is got to be equal to, the taxes have got to be equal to or greater than the amount of the Foreign Grantor Trust's claims of tax redirection. So, for example, if we were talking about a current mortgage, you could file 1099 OID if it was $1 million mortgage. The Foreign Grantors Trust identifies where that mortgage security is, files 1099 OID. The investment bank that is holding that mortgage security, that $1 million mortgage is balanced, it's discharged. The Foreign Grantors Trust filing the 1099 OID discharges the $1 million mortgage, and then $1 million worth of taxes is due to the Foreign Grantors Trust from the investment bank's